This right here is a massive piece of news that might have flown under your personal radar, but that doesn't necessarily mean it is any less consequential. You know those big cases, right, where how Trump is a convicted felon in New York and we're just waiting for the hammer to drop, and several other cases around the country, the one down there in Georgia, that'll eventually get underway. And then there's those two big federal cases, but oopsie daisy, one of them, especially the January 6th one, which eventually, when that does get tossed out, they're going to find it incredibly tough. We're talking about the leftists, the Democrats that are out there to hang their hat on the violent insurrection stuff anymore, because how many other investigations? Because you had the committee, the House committee, investigating that and coming up with nothing. You had Capitol Hill Police, you had the CIA, well, not the CIA, the FBI, Washington Police Department, turn up nothing at all to hold against Trump. They had to simply, and now has been determined, unconstitutionally appoint Jack Smith to try to dig up any dirt on Trump, and all they could do was send Steve Bannon to jail. But as for the other case, the one that, of the big four that were out there, pundits were looking at that going, well, that's probably the one that's the strongest. It's not necessarily any better of a case. It still has more holes than a block of Swiss cheese, and still won't stand up to appeal or scrutiny. But now, well, I guess we don't have to ever contemplate those outcomes, because the classified documents case, it has officially been tossed out. Now, in any other news week, this would be a gigantic news right up there. The same week that the SCOTUS decision about presidential actions, if done in an official capacity, are legal and not deemed worthy of prosecution, this story would be front and center. But because it, deeply exposes Democrat corruption, they were more than willing to just sweep that under the rug, because they have too much damage control to run on other fronts. So Biden's DOJ classified documents case against Trump dismissed after judge deems Jack Smith appointment unconstitutional. On Monday morning, Judge Aileen Cannon, which I don't really think that this decision was motivated by what happened over the weekend, simply because this was one of the first things to drop first thing in the morning, meaning that, it was just kind of routine. This had already been decided that clerks were crossing T's and dotting I's over said weekend, and it would just become official on Monday. But she dismissed the Mar-A-Lago documents case against Trump, stating in an order that Jack Smith's appointment as special counsel violated the Constitution. Exactly, and that has been something that has also been equally theorized since the commencement of this case. Former President Trump's motion to dismiss indictments based on unlawful appointment and funding of special counsel Jack Smith is granted. In accordance with Order ECF number 326, the superseding indictment is dismissed because special counsel Smith's appointment violates the Appointments Clause of the United States Constitution. 93-page Monday morning order statement. U.S. Constitution, Article 2, Section 2, Clause 2, Special Counsel Smith's use of permanent indefinite appropriation also violates the Appropriations Clause. It's almost like this guy should be charged with something, but that'll never happen. It's still the Biden DOJ. United States Constitution, Article 1, Subsection 9, Clause 7. But the court need not address the proper remedy that the funding violation given the dismissal on Appointments Clause grounds. Cannon wrote, the challenges raised in the motion to dismiss asked whether there was a statute in the United States Code that authorizes the appointment of special counsel Smith to conduct this prosecution. After careful study of the seminal issue, the answer is no. None of the statutes cited as a legal authority is the appointment, and cites the appropriate clauses, gives the Attorney General broad inferior officer appointing power or bestows upon him the right to appoint a federal officer any kind of prosecutorial power wielded by Special Counsel Smith. Nor does the Special Counsel's estranged statutory arguments, appeals to inconsistent history, or reliance on out-of-circuit authority persuade otherwise. Cannon wrote, in the Appointments Clause is a critical constitutional restriction stemming from the separations of power, and gives Congress a considered role in determining the propriety of vesting appointments power for inferior officers. But the position of special counsel effectively usurps the important legislative authority, transferring it to a head of department and process, threatening the structural liberty inherent in the separation of powers. Blah blah blah, legalese crap. If the political branches wish wish to grant the Attorney General power to appoint Special Counsel Smith to investigate and prosecute this action with the full powers of the United States Attorney. There's valid means in which to do so. He can be appointed and confirmed through a default method prescribed by the Appointments Clause, as Congress has directed for the United States Attorneys throughout American history, or Congress can authorize the appointment through the enactment of a positive statutory law consistent with the Appointments Clause. So it's almost like, Judge Cannon is pointing out, yeah, this was kind of like a show trial. You guys were just trying to flex your power, but unfortunately for you, there's this little old rag called the United States Constitution that you need to adhere to if you want to have any sort of teeth to your threats. Cannon later added that the framers gave Congress a pivotal role in the appointment of principal and inferior officers. The role cannot be usurped by the executive branch or diffused elsewhere, whether in this case or another case whether in times of heightened national need or not. In the case of inferior officers, that means that Congress is empowered to decide if it wishes to vest appointment power in the head of the department, and indeed, Congress has proven itself quite capable of doing so in many other statutory contexts. But it plainly did not do so here, despite the special counsel's strange statutory readings, nor does his appeal to inconsistent historical practice supplant the absence of textual authorization of his appointment. The same structural emphasis resonates in the context of the Appropriations Clause, which embodies a fundamental separation of powers principle, subjugating the executive branch to the legislative powers of the purse. Oh, basically, you didn't have the justification to wear the badge that you did, nor did you have the ability to receive monetary compensation for that. Really does suck to suck. Cannon's orders came after the Supreme Court ruled in July that Trump does have immunity for official acts as president. In his concurring opinion, words are hard, Justice Clarence Thomas called into question Smith's appointment as special counsel in the January 6th case against Trump. All right, separately to highlight another way in which prosecution may violate our constitutional structure. In this case, the Attorney General purported to appoint a private citizen as special counsel to prosecute a former president on behalf of the United States. But I'm not sure that any office of the special counsel has been established by law as the Constitution requires, Thomas wrote. By requiring that Congress create federal offices by law, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. If there is no establishing the office of special counsel occupies, then he cannot proceed with the prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. Oof, the FBI is currently sweating. In August of 2022, Trump's Mar-A-Lago residence in Palm Beach, Florida was raided by the FBI, and they were searching for documents they claimed were classified. And the only way that they could somehow, if they were just really kinking their necks to the side in order to justify, hey, Trump had international secrets, is if they would go ahead and interpret some readings under the Espionage Act where, any information is national defense information, therefore it cannot be disseminated in any form or fashion. It would have taken a bunch of hoops to jump through. And yes, of course, those were the most legally persuasive arguments that you could have levied in the documents case, but now that one's gone, the J6 case, that one's toast, care of the SCOTUS ruling. You've got the New York decision heading to appeals, and then you've got the Georgia case that is immediately undone by simply listening to one phone call. Now you've got Trump pretty much in the clear in regards to his legal cases, which is probably going to incite a bunch of other people, but eventually they're going to have to catch up to this stuff anyway. So for as much as this article breaks stuff down, let's just hear from a legal mind, a rather important legal mind in the form of Jonathan Turley. So somebody who I've used as a source before, but I do believe that Professor Turley taught at Georgetown, sounds about right, but at a very well-respected institution, okay, and he's been known to chime in on issues such as this, and he was even one of the more skeptical people in regards to the validity of the documents case, and he's been vocal in his opposition, and now he's just been proven correct. So the dismissal of the classified documents case is a seismic development. From the beginning of all of the cases, I have said that the Mar-A-Lago case was the greatest threat to the former president. It is now dismissed. Yeah, exactly, because you can point out something going, of all the cases that are there, it's definitely the tallest midget, but at the end of the day, we're trying to field a basketball team, and well, this was their three-point shot for Trump. Yeah, the easiest basket in the D.C. case, a far more favorable judge for Jack Smith. That case was inundated with presumptively privileged evidence and challenged charges. Judge Cannon's decision mirrors the views of many leading lawyers who see the same constitutional flaw that led Justice Clarence Thomas to expressly raise his issue in the recent opinion. There are good faith arguments on both sides of the question, but even critics must acknowledge that anomaly of having a constitutionally mandated confirmation process for U.S. attorneys, but then allow an ad hoc system of unilateral appointments for special counsels. Yeah, this opinion is still an outlier among the courts that have reviewed the question. The other courts have given short shrifts to the issue. Judge Cannon was criticized for giving this a challenge a full opportunity for briefing and argument in her court. Yeah, exactly. And even right now, for some of the people that are aware of this, have floated the idea of impeachment, but at this point in time, just stuff that shit. Okay, she came to the correct conclusion, guys. The decision is another example of how Smith misplayed his hand in piling on charges in Florida. If he had simply gone forward with the obstruction charge, he could have had a trial before the election. Yeah, exactly. You know, if they were going to bicker with the Library of Records, right, and Trump keeping documents at Mar-A-Lago and then just simply hang his hat on, well, he was a little bit late on responses, you might have got a federal charge, you might have got something there just on a sheer technicality, but no, you were going for broke, and well, and now you're in the poorhouse. And of all the cases that Trump would want to see dismissed from the Trump perspective, this is the one. For Trump's perspective, this has always been lawfare, and this is a second close miss in a week by his enemies. Whether the Florida case was lawfare or legitimate, Smith overloaded the case with charges that slowed it down and made it even more vulnerable to challenges. We will have to see how Smith will now respond to an appeal, and the possible refiling is by a confirmed U.S. attorney. I just don't imagine we see any sort of expedited process here between now and the election or inauguration. I just don't see that happening. Historically, he has not gone quietly into the night when faced with legal obstacles, and that is, at least something that you can go ahead and point back to, because he's also been historically overturned in a ton of his challenges. Cannon finds both unconstitutional elements in the appointment by Garland and the appropriations given to Smith, all without the consent of Congress. Upon careful study of the foundational challenges raised in the motion, the court is convinced that the special counsel Smith's prosecution of the action breaches two structural cornerstones of the constitutional scheme: the role of Congress in the appointment of constitutional officers and the role of Congress in authorizing expenditures by law. So exactly, man, they could have had something against Trump, technically, theoretically, right? Like if they wanted to go for lesser charges, but no. This is still the same administration, a lot of the same moving parts, right? That under a previous regime, under the Obama regime, were caught red-handed spying on Trump, caught red-handed working with foreign agencies to obscure certain election elements. Why would you think, for even a mere moment, that they wouldn't try to go all out, bury Trump, put him behind bars? Because if they think one aspect of this stuff is rigged, why not just go for the whole hog? But in reality, there's still some good people that are out there. They haven't corrupted everything. Most things, but not everything. And unfortunately, he ran into a wood chipper, form of Aileen Cannon, Judge Aileen Cannon to you, who just cleared that runway to a November victory, and even more insanity as these months wind down towards the election, if we're being completely honest. So with all that said, thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.